defendants from the Arkansas Department of Correction. D, that these conditions will be satisfied on Friday, August 19, 2011. And E, the petitioners agree to dismiss any and all outstanding claims and proceedings relating to this matter. The judge noted, the court finds that all three defendants with respective defense counsel in attendance consent to and request this court to set aside previous verdicts and set all three cases for a new trial for the purpose of allowing the three defendants to enter the negotiated pleas discussed herein. And the state agreed to that too. Finally, he wrote, the court finds that although compelling evidence that a new trial would result in an acquittal, there is also sufficient evidence of a jury to find guilt beyond a reasonable doubt. Should I read it again? The court finds that although compelling evidence exists that a new trial would result in an acquittal, there is also sufficient evidence of a jury to find guilt beyond a reasonable doubt. That is the essence of an Alford plea. Each defendant then stood and stated that upon their lawyer's advice, they were freely and voluntarily pleading guilty while maintaining their innocence as allowed in North Carolina v. Alford. The defendants, their lawyers, and prosecuting attorney Ellington then entered the plea and sentence recommendations that they had earlier hammered out. On three new charges, each of first-degree murder, the prosecutor recommended that each man be sentenced to 18 years and 78 days in prison, the time they had already served. I found it interesting that in a list of aggravating factors accompanying that plea, the only one marked was the one concerning the age of the victims. Use of a weapon as a key element at the trials was not noted. Another order by Judge Laser suspended impositions for an additional 10 years, so long as the three stay out of legal trouble. And a final order sentenced each of the three to the time they had already served. A couple of other points I found interesting were that while the men were not allowed to possess firearms or be around anyone who did, exceptions were made for Eccles and Baldwin, who planned to leave the courthouse with musician Eddie Vedder, who had armed bodyguards. Also significantly, they were all allowed to leave not only the state but the country, which I am told Eccles is about to do. And none of the three was required to register as a sex offender. A minor point, perhaps, but one that further undercuts the state's claim that the 1994 trials were sound and that the men who had just been freed were indeed the actual killers. Jason Baldwin immediately left. Well, there was a party at the Madison Hotel that night. Eccles and Baldwin attended that, and Jesse Miskelly went with his family back to Marion, Arkansas. After that, Baldwin left for the Pacific Northwest. He's told me that life since his release has been a roller coaster ride, but mainly he's having a ball. Yesterday, on my way here, I stopped in West Memphis to visit Jesse. He's surrounded by family and close friends, but tired of being a spectacle whenever he's in public. Nonetheless, he said that his encounters with the public have all been good. People congratulating him, patting on the back, and wanting to be photographed with him. He said he had had no negative reactions. He's studying to get his driver's license and looking for a job. I told him that since I'd be in Memphis, I'd put out the word. He is able to do basic auto mechanics, construction, and lawn work, and if anyone wants to help him, let me know. I'm Mara at maraleveritt.com. As for the state of Arkansas, case closed. Murderers caught, murderers convicted, murderers served their time, murderers released. The problem is that a huge disconnect has developed between what happened in this case legally and how the public sees it. In general, in Arkansas, the convictions are now seen as having been cooked, and the men's sudden release is viewed in the same way. Nobody I've met is fooled by the state's claim that in the 18 years since the murders, the fiber evidence technician has died, and other witnesses are finding events harder to recall, so prosecution would be difficult, and hence their interest in not pursuing new trials. Rather, a sorry cynicism has developed that politicians who fought tooth and nail to retain the convictions woke up and discovered themselves on the wrong side of public opinion. And that situation, not the truth, not justice, was righted. I find it sad. The court has ruled the men are free, but while Michael Moore and Stevie Branch and Christopher Byers, the three victims at the heart of this story, lie in their little graves, state officials insist that the men that they just set free actually were their killers. There's no interest on the part of the state of Arkansas for looking into their deaths beyond that. That's about where things stand right now. Supporters are asking that Governor Mike Beebe pardon the men. The governor has said he won't. There is support continues. There is interest still in finding out on the behalf of supporters and private investigators to find out who actually committed the murders. Prosecuting attorney Scott Ellington said at a panel discussion at the Clinton School in Little Rock a couple of weeks ago that he was open to new evidence in this case if it was presented to him by any of the legal teams. So the legal teams are still working on it. There was an additional hair found with the victims that has not been identified, and a fingerprint that has never been identified. So there's something to work with, probably not a lot, but it keeps the question open. Meantime, I'd just like to close by suggesting, the guys are free. And meantime, we have in a state nearby just executed Troy Davis. I'm suggesting that if something as astonishing as taking a man off of death row in Arkansas can happen in 1 week, and a couple of weeks later, a man can be executed a couple of states over based on little or no evidence, there's a big problem in this country with the death penalty, and we need to stop it. Thank you very much for having me, and I'm happy to answer questions with whatever time is left.
Next class is at 1 o'clock, is that right, Professor? And their class at 1, is that right?
Not mine, but somebody might have class at 1.
I
postponed mine for 1:30.
Okay. We have time for questions. So if you have any questions, please raise your hand and Jennifer will identify you.
Don't make them hard.
Did the governor give any specific reasons why he refused to pardon them?
No.
Professor Mulroy?
Could you tell us a little more about the alleged juror misconduct?
Be glad to. As I mentioned, the trials were separated. Jesse Miskelly was tried first because of his self-implicating statement. And then he refused to reappear at the second trial and repeat it when Eccles and Baldwin were tried. Because of the constitutional requirement that defendants be allowed to face their accusers, Ms. Kelly was not going to be present at their trial accusing them. Because of that, prosecutors were not allowed to even mention anywhere in the trial that Jesse Miskelly had confessed. He had been convicted on the basis of his statement to police, but that was off limits for the second trial. at one point, one of the police officers said something like, he mentioned Miss Kelly's confession, and Judge Burnett, the defense arose and objected and called for a mistrial right at that moment. Judge Burnett said, I think everybody here knows that Miss Kelly confessed, and went on with the trial. The men were convicted. Years later, it was discovered that the jury foreman at that second trial had contact with a lawyer in Little Rock. Follow me here. This is a man in Jonesboro selected to be the foreman of the jury at the West Memphis trials. He had a brother in Little Rock who was facing a criminal charge of rape. And the man in Jonesboro, a businessman, was paying a Little Rock lawyer for his brother's defense. So while the West Memphis trial was going on, he was calling the lawyer in Little Rock to discuss his brother's case. But he also continuously, according to an affidavit later filed by the attorney in Little Rock, talked about what was happening in the jury proceedings at the West Memphis trial. The lawyer in Little Rock said nothing about this at the time or for several years later, believing that he was bound by attorney-client privilege not to discuss anything that had transpired. However, he had mentioned something about this to a few of the people he worked with. After the wife of Damian Eccles, Lori Davis there, rounded up a group of people in Little Rock to begin an organization in Arkansas to begin to sway the matters in the state, because nothing mattered except what happened in the state. At a dinner held, a restaurant held a dinner to which several lawyers were invited. And one of the people in attendance, they explained the case, asked for support, and one of the lawyers said, well, I used to work with a guy who said that he was in touch with the jury foreman all through the case. That was a big, big breakthrough. They got in touch with that lawyer. He got in touch with his lawyer, and basically they decided between them that the right thing to do was file an affidavit with the court and expose, at least report on this, these continuous conversations that had occurred throughout the West Memphis trial. In that affidavit, the Little Rock lawyer said that the jury foreman had said he believed from the start the guys were guilty, that he was willing to mislead during voir dire because he wanted to be on the jury, that he was frustrated with the prosecution, that the other jurors did not seem inclined to convict, and that if the prosecution didn't start doing a better job, it was going to be up to him to change the other jurors' minds. The judge Judge Burnett again, sealed that affidavit, and it went unknown for several years, unknown except to a few attorneys working on the case, including the defense attorneys, who were the ones who brought it to court. But it remained sealed from the public for years. Then, an examination of records kept during the trial revealed a flip chart that the jurors in this case had kept, in which they had on one page listed the pros and the cons for conviction.